Welcome to the viewers of UGCE Pathshala. Today I am going to present before you International Instruments and Covenants in Access to Justice Module 2. This module is written by my colleague Ms. Kim Couto, Senior Faculty. I am going to present this module on behalf of my colleague. I am Dr. Shabbir Ali, Associate Professor. Both of us were working in VM Salgonkar College of Law, Panji, Goa. The structure of today's presentation is we are going to look into access to justice and municipal enactments, access to justice and international instruments, mainly with respect to UDHR, ICCPR, ICESCR. Besides that, we are going to verify various regional human rights treaties and other agreements, UCHR, ACHR, ACHPR. These are the various regional human rights treaties we are going to look into, and afterwards we are looking into few case laws and obligations of the state with respect to access to justice. By going through this module, the reader will be able to understand insight into the international human rights instruments on access to justice and appreciate the scope and extent of these rights. Understand the universal recognition and acceptance of access to justice as human rights. Identify the key components that constitute the rights of access to justice. Recognize that the state has obligation to ensure access to justice to its citizens. Appreciate the role and importance of the treaty bodies in promoting access to justice. Now, let me present before you the scope of the presentation. This module explains the principles of international law on access to justice. This module examines in particular human rights on access to justice. This module highlights interaction between municipal law and international law in protecting and promoting access to justice. Now, let us look into introduction. Access to justice refer to ability of the citizens to use justice. Various institutions to obtain and redress their common grievances or problems. Access to justice is facilitated when the domestic and municipal law makes available effective remedies for the enforcement of rights in accordance with international human rights standards. Access to justice occurs at two levels, national or municipal level, and second is international level. Let us first look into municipal level and access to justice. In case of violation of legal rights, municipal laws must provide citizens mechanism to avail the necessary relief, where access to justice is recognized as a legal right under the ambit of constitution or national laws of the state. National laws are in accordance with international law principles, and a good citizen can effectively translate his rights into action. Once Indian government signs any treaty or convention, to implement such international instrument, powers are given to Parliament under Article 253 to make suitable law in the country to comply with international commitment. So, under this article, Parliament can make a law in order to comply with international instruments to the whole of India or to any part of the territory. Under this article, Indian Parliament made various enactments to comply with international instruments. However, where municipal law is not in accordance with international legal principles, access to justice is affected. Access to justice has grown not merely due to legal right, but has acquired the status of human rights. International human rights law lays down binding standards with respect to access to justice. Ratification of such human rights instruments imposes on states obligation for implementation of principles contained therein. Access to justice under international human rights law. Access to justice has evolved from a moral obligation to a legal right. This legal right in recent times earned the status of human right under the international human rights treaties. In the beginning, varying moral rights are converted into legal rights. Legal rights once again they are converted into human rights. Human rights are rights available to every person because he is born as a human being. So, human rights cannot be denied to any person who is born in this world as a human being. Hence, it may be said that access to justice has its foundation in the various provisions of international human rights law, which has developed binding standard in respect of such conventions. Two kinds of international human rights instruments are available, that is binding instruments and non-binding instruments. Let us look into international humanitarian law instruments. There are number of human rights instruments which prevails on access to justice, some of which are binding and others are non-binding. Those states which have ratified the provisions of the instruments are generally bound by them. Binding instruments. The first one is Universal Declaration of Human Rights 1948. It is popularly known as UDHR. This UDHR was proclaimed on 10th December 1948. 10th December is celebrated as World Human Rights Day. This UDHR lays down for the first time the key components of access to justice. Though not directly referring to the phrase access to justice, the declaration touches upon its various components. Article 8 of the declaration reads, everyone has the right to an effective remedy by the competent national tribunal for acts violating the fundamental rights granted to him by constitution or by law. Article 8 of the declaration also demonstrates that the state should protect and promote the fundamental rights of their citizens by ensuring their accessibility to tribunals or courts which have the capacity to enforce their claims. Hence, where a man has a right, he must, according to the declaration, have the means to support and maintain the right and must be able to avail an effective remedy in case of its violation. Whenever there is a violation of rights of any person, he must avail remedy before any appropriate authority which should be effective in nature. Article 7 to 11 of UDHR mainly deals with criminal cases, and these articles prescribes right to a fair and public hearing by an independent and impartial tribunal. So, these articles clearly inform that there should be fair trial conducted by appropriate authority. The authority should presume that every person is innocent till his guilt is proved before the authority. All the guarantees necessary for the defense. The authority should provide all the types of defenses the counsel or the victim or the accused person can use before the appropriate authority. UDHR lays a common standard of achievement for all peoples and all nations. The principles enshrined therein developed into binding juridical commitment with the International Bill of Rights. The International Bill of Human Rights consists of Universal Declaration of Human Rights, which is known as UDHR. The next one, International Covenant on Economic, Social and Cultural Rights, known as ICESCR, and International Covenant on Civil and Political Rights. It is popularly known as ICCPR, and there are two optional protocols. The rights outlined in the UDHR became binding with the adoption of two treaty instruments, namely ICCPR and ICESCR in the year 1966. Let us first look into various provisions laid down under ICESCR in dealing with access to justice. Article 2(1) of the Covenant indirectly addresses the right to access to justice. It says each state party to the present covenant undertakes to take steps individually and through international assistance and cooperation, especially economic and technical, to the maximum of its available resources with a view to achieving progressively the full realization in the present covenant by all appropriate means, including particularly at the adoption of legislative measures. The ICESCR thereby lays down states must have proper grievance redressal mechanism in place for their citizens. The ICESCR has its own monitoring body known as the Committee on Economic, Social and Cultural Rights. This committee monitors the fulfillment of provisions including access to justice obligation. International Covenant for Civil and Political Rights, the next important covenant which deals with access to justice. The ICCPR was adopted by a resolution of United Nations General Assembly on 16th December 1966. The ICCPR lays down positive obligation on state parties to respect the core doctrine of access to justice. Article 2, paragraph 3 of ICCPR stipulates, ensure that any person whose rights or freedom as herein recognized or violated shall have an effective remedy, notwithstanding that violation has been committed by persons acting in an official capacity. Second, to ensure that any person claiming such a remedy shall have his rights thereto determined by competent judicial, administrative or legislative authorities or by any other competent authority provided for by the legal system of the state and to develop the possibilities of judicial remedy. 3. To ensure that the competent authority shall enforce such remedies when granted. Article 14 of this convention incorporates the most important key components in access to justice. The principles of equality, fair hearing and fair trial are to be granted to all persons who are being tried before any court. Additionally, the right to be tried without undue delay, right to have legal assistance are also laid down or to be complied with. The important principles laid down under Article 14 are also well recognized in our Indian law as well as they are incorporated by our Indian judiciary. Thus, Article 14 of ICCPR paragraph 1, ICCPR includes guarantees with regard to a fair trial and also encompass a stipulation with regard to access to courts. A perusal of various human rights instruments shows that the phrase access to justice does not find express mention in the various human rights treaties and documents, but various components of the rights such as the right to fair treatment, right to legal aid, absence of unreasonable delay and such other components are given due recognition and important in these instruments. Is that they all affirm and promote the right to access to justice, though they may differ in their specific provisions, they all condemn any practice that encroaches upon the individual's right to fair and equal treatment. They provide not only for the continuance of the traditional protection under the civil and criminal law, but they also stipulate protection in all spheres of human endeavor and interaction. Some of these human rights instruments focus on protection to vulnerable people and communities. There are also other United Nations instruments which specifically affirm the right to access to justice and for treatment. The Convention on the Rights of the Child, for instance, keeping in mind the best interest of the child, recognizes the right of the child to promote access to legal and other appropriate assistance, including the right to challenge the legality of his deprivation of his or her liberty in case of its occurrence. Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power in the year 1985 and the Basic Principles and Guidelines on the Rights to a Remedy and Reparation for Victims of Gross Violation of International Human Rights Law in the year 2005. Access to justice does not find express mention under international humanitarian laws. Key components of access to justice are found in the international human rights law. Access to justice requires a more comprehensive and liberal interpretation. Let us look into other conventions which deals with access to justice in one way or other way. In addition to the major United Nations instruments recognizing the right to access to justice as fundamental human rights, the International Conventions on the Elimination of All Forms of Racial Discrimination 1965, Convention on the Elimination of All Forms of Discrimination Against Women in the year 1979, the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment in the year 1984, Convention on the Rights of the Child 1989 and International Convention on the Protection of the Rights of All Migrant Workers and Members of their Families in the year 1990. These are some of the other United Nations standards related to access to justice. Now, let us look into Regional Human Rights Instrument which deals with access to justice. The Regional Human Rights Instruments mainly three categories: European Convention for the Protection of Human Rights and Fundamental Freedoms in the year 1950, it is known as ECHR, American Convention on Human Rights in the year 1969 known as ACHR, and African Charter on Human and People's Rights 1981 ACHPR. Now, let us look into each regional convention and provisions dealing with access to justice. The first is European Convention for the Protection of Human Rights and Fundamental Freedoms in the year 1950. This convention is binding on the member states in Europe. Article 6 of this convention underscores components of access to justice. ECHR lays down that states must ensure a fair and public hearing for grievances within a reasonable time. Such a hearing must be given by an independent and impartial tribunal established by a law. In the European Convention, therefore, human rights of access to justice is seen as a right to a fair hearing. The next is American Convention on Human Rights in the year 1969. This convention specifically recognizes the rights to a fair trial under Article 8. The right to equal and judicial protection is to be found in Article 24 and 25 of the convention respectively. Article 25 in particular stipulates prompt recourse to a court or tribunal in case of violation of rights. The next important regional convention is African Charter on Human Rights and People's Rights in the year 1981. This charter clearly contains the guarantees of access to the courts. It mentions that every individual has a right to have his cause to be heard under Article 7. This right includes right to appeal to the competent national organs against acts of violating his fundamental rights as recognized and guaranteed by conventions, laws, regulations and customs which are in force. The right of access to justice appears in different forms, as in access to courts, or as the right to fair trial, or as the right to an effective remedy, or as the right to judicial protection. Despite the differences in language used in the enactments, the components of access to justice are clearly visible in the mentioned treaties. The right is subject to restrictions and regulations, as is the case with all other rights. Thus, the imposition of time limit, the grant of immunities, the requirements of leave, or mandatory compliance with the certain legal procedures are some of the valid restrictions on the right of access to courts that have been recognized in these conventions. Although some of the essential dimensions of access to justice have been touched, some of its other components have been overlooked in the core of human rights instruments as we discussed. The right to an effective remedy, right in full equality to a fair and public hearing by an independent and impartial tribunal, right to be tried without undue delay in criminal cases, and right to legal assistance, all these are recognized under these conventions. Let us conclude with respect to regional human rights treaties. Provisions of access to justice are clearly visible in the regional human rights treaties. The right is subject to restrictions and regulations, as is the case with respect to all other rights. Now, let us bring to the RS Convention 1998. This convention mainly deals with access to information and public participation in decision making and access to justice with respect to environmental matters. Environment being one of the most important area which is decided even at the international conventions in their 1972. Every country made various agreements to protect our environment. This convention was signed on 25th June 1998. Under this convention, Article 99 establishes right to information as well as access to a review procedure before a court or other independent and impartial body if a request for such environmental information has been ignored or wrongfully refused. And this convention mainly looks into access to information as a right available to people in case of environmental damage or environmental pollution. The next is Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power in the year 1985. Rights of crime victim are explicitly recognized and crime victims are defined in this declaration. Access to justice and fair treatment which enables the victim to obtain redress for the harm suffered through judicial or administrative mechanism. He has the right to restitution, compensation and assistance are stipulated under this convention. Now let us look into other important instruments which deal with access to justice. One of the most important instruments is World Trade Organization WTO dispute resolution mechanism. The WTO dispute settlement body DSB and appellate body provides a means for WTO members to resolve the dispute arising under WTO agreement. The DSB comprises a panel of corporate and trade lawyers and officials who preside over hearing as judges or arbiters of dispute in case of dispute among the members. Thus, access to justice is provided for members under this WTO. The next is North American Free Trade Agreement known as NAFTA. NAFTA provides an investor state dispute mechanism which enables investors to arbitrate their claims under NAFTA directly against the host government without the intervention of the national government of the investor. By this, a private actor has direct access to international remedial proceedings or access to justice. Next, we are referring to United Nations mechanism that promote access to justice. Here we are referring to two important United Nations mechanisms, that is United Nations Human Rights Council and High Commission on Human Rights. First, let us look into United Nations Human Rights Council. This council addresses human rights violations, promotes human rights assistance and education. It also reviews states' human rights records and works to prevent human rights abuses, responds to emergencies and serves as an international forum for human rights dialogue. The next mechanism is the Office of the High Commissioner for Human Rights. This mechanism ensures the protection and promotion enjoyment of human rights established under United Nations Charter. It does facilitate access to justice. The next is Rome Statute of the International Criminal Court 1998. This court established under the Rome Statute of 1998. ICC ensures justice to victims who have suffered the violation of their rights in the following cases. The first one, crime of genocide, crimes against humanity and war crimes. Crime of genocide means where there is a elimination of entire community. The community may be cultural, ethnic, caste and creed. If any community, one community try to eliminate other community, we are calling it as genocide. Crime against humanity, any crime against the society or public we can bring under crime against humanity. War crimes, whenever the war criminals are affected or their rights are violated, they can claim benefit or protection under ICC. Rome Statute 1998, the Rome Statute provides opportunity to the victim to be heard and to obtain where appropriate some form of reparation for the harm suffered. So, if you refer to the provision victim to be heard, it is nothing but the following the principles of natural justice. The human rights movement which gained momentum following the Second World War. This was further crystallized the obligation of the state to provide effective access to justice to its citizens. The various United Nations declarations and more importantly, the provisions of the various conventions which have been ratified by the parties have become legally binding on the latter. Accordingly, member states are obliged to take all measures to ensure that they provide effective access to justice to their citizens in accordance with the provisions of human rights laws. So, after going through all this thing, all the conventions, and that is at international level as well as we can say at various national levels, now let us bring it to obligations imposed by these instruments on the states. The state has to provide mechanism to dispense justice. It also has to provide for legal remedies for the violation of legal rights. After going through international enactments dealing with access to justice, now let us bring into few case laws to deal with access to justice. The first case is Golder versus United Kingdom. In this case, the European Court of Human Rights observed that the fair conduct of a civil proceeding is meaningless if one does not have the right to bring the proceedings. It further stated that the convention presupposes the right of access to the court just as it presupposes the existence of courts themselves. The next case is Erie versus Ireland. In this court again, the European Court of Human Rights held that the fulfillment of a duty under the European Convention on Human Rights requires positive action by the state, and thus it involves a positive duty to ensure effective access to the court. Ashington versus United Kingdom. In this case, the ECHR accepted that limitations may apply in respect of right to access to justice. Now, let us get into the concern regarding access to justice under international instruments and covenants. Some of the essential dimensions of access to justice have been touched upon, but essential components of access to justice have been overlooked. Uncertainty and indecision exist as to the exact content and scope of the right of access to justice. Emphasis is more on access to courts as justice dispensation mechanism. So, after going through today's presentation, let us summarize what we have gone through during today's presentation. First, we have gone through the differences between national law as well as international instruments dealing with access to justice. We verified various international instruments including UDHR, ICCPR, ICESCR. Further, we verified various regional instruments dealing with access to justice, that is European Convention on Human Rights, American Convention on Human Rights, African Charter on Human and People's Rights, and we discussed even about the role of WTO and International Criminal Court in dealing with access to justice. We touch upon few case laws with respect to access to justice. Thank you for your patient listening. I wish you all best wishes.